I had contact with my aunt who had contact with him. He said he would be here for today.
Okay, he's not here.
Before this courtroom even gets into the heart of any case, we already see a familiar reality of the justice system. Delays, missing parties, and the constant balancing act judges must perform to keep proceedings fair while keeping the docket moving. What looks like a quiet administrative moment actually reveals how complex court scheduling can be. Judges like Judge Simpson handle dozens of cases in a single session, and every delay, even one absent person, can ripple through the entire calendar. Now notice the judge's response here. Instead of immediately penalizing the absence or dismissing the issue, he chooses patience. He decides to call other cases and come back later. That might seem simple, but it reflects a key principle of courtroom management, giving every party a reasonable opportunity to appear. But here's something to think about. When someone fails to show up for court, the consequences can range from a simple rescheduling all the way to warrants or sanctions. So the judge's calm reaction signals something important. This likely isn't being viewed as deliberate avoidance yet. As this session unfolds, we're going to see a series of very different cases, each revealing how the legal system processes negotiations, misunderstandings, and serious criminal decisions in real time. And some of the moments coming up may surprise you.
All right. Well, let me wait a few more minutes. I'll call some other cases and then we'll see if he arrives. All right.
Okay.
Thank you. Court does call the case, People's State of Michigan versus Raymond Honeycutt.
Yes, sir.
Good morning, Your Honor. Ally Zend on behalf of the people seeking permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Caitlin Kirby.
Permission to practice is granted.
Good morning, Your Honor. Gina Noveski, First Assistant Public Defender, on behalf of Mr. Honeycutt, who is present.
I have not had no contact with my attorney, sir.
Yes, sir. Let me explain that. Your Honor,
yes.
I did try to contact Mr. Honeycutt as instructed by MDOC. However, when I called, I got a message that they were under emergency immobilization. I tried calling multiple times and could not get through. So I do apologize to Mr. Honeycutt and the court for that. But we would need to
something having to do with the facility, correct?
Yes, that's my understanding.
Right. Okay. So you would like an adjournment of this proceeding?
Yes, Your Honor. And I did request any video from Ms. Kirby as well.
Yes, excuse me, Miss Geneva. Yes, I'd like to talk to you, please. Let's speak to you.
Sir, did you just hear what she said?
No, yes.
Did you just hear what she said?
No, I didn't hear. I didn't hear you.
I didn't think so. You weren't listening. What she said was she tried to contact you in accord with MDOC procedures. There was something with the facility. Just listen to me.
This exchange might seem small, but it highlights something critical about courtroom dynamics: communication between incarcerated defendants and their attorneys. When someone is in custody, especially within the Michigan Department of Corrections system, access to communication can be limited or disrupted by facility lockdowns, emergency immobilizations, or administrative restrictions. That's exactly what the defense attorney is explaining here. She attempted to reach her client but ran into a facility lockdown situation. From the court's perspective, this matters because a defendant must have the opportunity to consult with their lawyer before critical hearings like a probable cause conference. Judge Simpson's response is interesting here. He steps in to clarify the situation directly to the defendant, and he almost acting as a translator between legal procedure and the defendant's frustration. That's actually part of a judge's role, ensuring the defendant understands what's happening so that the process remains fair. But here's the question for you watching this. If you were in the defendant's position and couldn't reach your lawyer before court, would you trust that the delay is just a procedural issue? Or would you feel like the system is already working against you? Moments like this can heavily influence how defendants perceive the justice system moving forward.
Because otherwise I'm going to be done. I'm just going to give you a date. I'm going to try to explain it to you. She tried to contact you, could not get through, and she apologized to you, but it's not her fault that she couldn't do it. So she's asking for an adjournment so that she can arrange a time to talk to you about the case.
Yes, sir.
Probable cause conference will be adjourned to September 28th 2023, 9 a.m., or as your Zoom invite indicates, bond continued. Thank you.
Thank you, Your Honor.
Okay. All right, thank
Mr.
you.
Matthews here.
28, okay.
Court calls the case of the people of the state of Michigan versus Zachary Grimsley. Recall.
Maria Rosinski on behalf of the people.
Mr. Matre,
Yes, Judge. Sorry, I was just parking. Good morning, Judge. I'm Chris Metcher here on behalf of Mr. Grimsley. Today's the date and time set for a probable cause conference. Mr. Grimsley's in the Michigan in the MDOC at this time, Judge.
Now we shift into another case entirely, and the discussion quickly moves towards scheduling a preliminary examination. This is a critical stage in felony cases. During a preliminary examination, the prosecution must show that there is probable cause to believe a crime was committed and that the defendant likely committed it. It's not a full trial, but it's one of the first real tests of the prosecution's evidence. Notice how much of this conversation revolves around scheduling logistics. Transport from MDOC, witness availability, attorney schedules, and courtroom space. To viewers, it might seem bureaucratic, but these logistical factors can actually influence the pace and strategy of a case. For example, if a key witness can't appear on a specific date, it could delay proceedings for weeks. That time can allow attorneys to negotiate, and gather additional evidence or even reconsider charges. Here's something worth thinking about. Do you think these scheduling delays help defendants prepare better defenses? Or do they sometimes drag out the stress of the legal process longer than necessary? Either way, this is the behind-the-scenes reality of how criminal cases slowly move through the system.
yes, he is. Mr. Grimsley, identify yourself, please.
Zachary Grimsley.
All right. What are we doing on the case today?
Judge, I would set this for exam, see if the victim is going to appear. I don't know if you're still doing Zoom exams to see that, or
No, we are
or
not.
if
They're all in person.
okay.
This one would be set for the 19th unless there's an agreement between the parties to set it for a different date. Well, we'll have to actually probably go to the 26th for transport reasons, but when do you want it?
Judge, I would ask if it pushed out a bit. I'm gone the end of the month, so if I could do October 12th or October 26th. I know Mr. Grimsley, you're in MDOC
October
until
10th.
when? October 10th? Oh, you guys do it on Monday. Sorry. October 10th.
No, on
Mr.
Tuesdays.
Grimsley. Oh, Tuesdays. Okay. October 10th, I'll make it work, Judge. I'll have to. Is it in the morning or afternoon? I'm not sure about your.
It's in the
your
morning.
schedules. Okay. Well, we'll do October 10th, Judge. I'll make it work. and I'll
Preliminary
be there,
examination in person, October 10th. Without objection, 2023, 9 a.m. And that is before Judge Fresh Hour.
Okay. I'll make sure I find that out.
Bond
Thank you,
will
Judge. And Mr.
continue.
Grims. Okay. Thank you. And Zach, I'll
Thank
talk
you.
to you before then. Okay.
Okay.
Okay. Thank you, Judge.
Calls the case, People versus James Lyle.
Good morning, Your Honor. Jonathan Emmons on behalf of the people.
Ready, Judge. Floor Feaster, Assistant Public Defender on behalf of Mr. Lyle. Mr. Lyle, please state your name for the record.
James Lyle.
Thank you, sir.
I had some good conversation with Mr. Evans. We have almost reached a resolution to a misdemeanor on this file. We're gonna have to get the plea form drafted and submitted to your office so we can enter that plea. If we could have a brief adjournment to get that done, we'd appreciate it.
This moment gives us a glimpse into one of the most common outcomes in criminal courts: plea negotiations. Despite the drama we often associate with trials, the vast majority of criminal cases never actually reach a full jury trial. Instead, they're resolved through negotiated pleas between the defense and prosecution. Here, the defense attorney is indicating that the case may be reduced to a misdemeanor. That's a huge difference compared to felony charges. Felonies can carry long prison sentences and permanent consequences like loss of certain civil rights, while misdemeanors typically involve shorter jail time, fines, or probation. But there's also something interesting happening when the defendant interrupts asking what the plea was. And Daniel House and Plankin Williams you. The judge immediately steps in and reminds him that those details will be explained privately with his attorney. That's important because plea negotiations often involve strategic discussions that shouldn't be broadcast openly before they're finalized. From a legal perspective, The judge is protecting both the process and the defendant's right to confidential attorney-client discussions. But think about this. If you were the defendant in that chair, hearing your case discussed without fully knowing the details yet, would you feel anxious, or would you trust your attorney to handle the negotiations behind the scenes?
Probable cause
And I don't.
conference. I'm sorry. What's wrong, sir?
I was trying to ask, can I know what the plea was?
Well, he will talk to you about that. We don't need the whole world to know at this point. But let him, here's what I'll do. I'll adjourn it to September 28th, 2023, 9 a.m. And that way Mr. Lyle, he'll get in contact with you, explain everything to you, answer all of your questions before then, okay?
Okay.
If I could just ask,
All right.
Mr. Lyle, does he have a projected out date? Just so that I know. If there is one.
Not at this point in time. This is the reason that I'm here is because of this. This
All
is
right.
a violation.
Okay. All
Got
right.
it.
Thanks.
All right,
Just
thank
wanted
you.
to-
Thank you, Judge.
Court calls the case, People versus Erica Insoon Miller.
Again, Your Honor, Jonathan Emmons on behalf of the people.
Good morning, Your Honor. First Assistant Public Defender Queena Anderson with and on behalf of Ms. Miller. Ms. Miller, will you state your name, please?
Hi, Erica Miller.
And I have before me a plea form. Is that what we're doing?
I sure hope so, Your Honor.
Yes, Your Honor. At the appropriate time, I'll be requesting immediate sentencing.
Okay, whatever. No, I'm okay. All right. The plea form indicates that the defendant will be pleading guilty to an added count 2 of use of methamphetamine. I don't have the maximum penalties on here and need to have that. Whoever prepared this form, what are the maximum penalties on it?
Your Honor, that's my fault. My apologies. It'll be on
I
all the
know.
other ones.
Now we arrive at one of the most substantive moments in this hearing, a guilty plea being formally entered. When a defendant pleads guilty, the court must ensure that the plea is voluntary, informed, and legally valid. That's why the judge goes through such a detailed series of questions. These questions aren't just formalities. They are part of what's called a plea colloquy, a required process where the judge confirms that the defendant understands the charges, the maximum penalties, and the rights they are giving up. Those rights include the right to a trial, the right to confront witnesses, and the presumption of innocence until proven guilty. By pleading guilty, the defendant waives those protections. Notice also that the charge is for use of methamphetamine. but classified here as a misdemeanor with a maximum penalty of 1 year incarceration or a $1,000 fine. This moment represents a turning point in the case. Once the plea is accepted, the legal battle is essentially over. The focus shifts entirely to sentencing. And here's something for the viewers to consider. When someone admits guilt in court like this, do you believe it's always a genuine acceptance of responsibility? Or sometimes a strategic decision to avoid harsher consequences?
It's a 1 year misdemeanor, so punishable by up to 1 year and a $1,000 fine.
All right.
$2,000.
We'll be pleading to the 1 year use of methamphetamine. Upon her successful plea to that charge, count one would be dismissed, and there is, I'm sure they talked about it, no objection to immediate sentencing. That's the court's full understanding of the agreement. Is that correct, counsel?
That is correct, Your Honor.
Yes, Your Honor.
All right. Ms. Miller, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do, Your Honor.
State your name for the record, please.
Erica Ensign Miller.
All right. Ms. Miller, it is this court's understanding that you're going to plead guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
I do, sir.
And understanding that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, ma'am?
Yes, sir.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
Um, I am on probation.
You're still on probation? All right. Just so that you understand, this entry of a plea in this case could be a violation of your probation. If it is considered a violation of your probation, you could be sentenced potentially to the maximum allowable under the other charge or charges. You understand that?
This is a critical warning from the judge, and it reveals how interconnected criminal cases can be. Even though this charge is a misdemeanor, the defendant is currently on probation from another case. That means this guilty plea could trigger a probation violation, and that violation could carry its own consequences, sometimes even more severe than the original misdemeanor sentence. In other words, a seemingly minor plea can cascade into a much larger legal problem. Judges are required to warn defendants about this risk before accepting the plea. If the defendant later claims they didn't understand the consequences, the plea could potentially be challenged. So what you're witnessing here is the judge ensuring the record clearly shows that the defendant understood the stakes. This moment highlights something many viewers don't realize. Criminal cases rarely exist in isolation. A single decision in court can affect multiple cases, probation conditions, and future sentencing outcomes.
Yes, sir.
And understanding that, you still wish to enter this plea.
I do.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, they haven't.
Has anybody threatened you or coerced you?
No, they haven't.
You're doing this voluntarily,
I am, sir.
of your own free will,
Yes,
and because you believe that you are indeed guilty of this offense?
I am.
April 17, 2019, at the location of 2201 Hogback Road, that being the Washtenaw County Jail. Tell this court what you did on that date that makes you think that you're guilty.
I was in possession of a baggie of methamphetamine. I came to the court to try to clear up a warrant and had illegal controlled substance in my pocket. When I was searched, it was found, and I was subsequently charged with that.
Okay, did you use it, ma'am?
That was what I was using at the time, yes.
Okay, had you used the methamphetamine?
Yes,
All right, and you knew what you were using was methamphetamine?
that's correct.
All right, counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor. Thank you.
Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. And Ms. Anderson, as to your request for immediate sentencing.
Yes, Your Honor. Ms. Miller has been in Clinton County Jail as well as Ingham County Jail since the arraignment in this case. She's been in so far a total of 508 days since the arraignment date. She's currently in custody on the Ingham County case where she will be sentenced on October 2nd with the expectation that she'll be sentenced to a minimum of 36 months in MDOC.
Here we hear a powerful argument from the defense regarding time served. The attorney explains that the defendant has already spent over 500 days in custody across multiple county facilities since the arraignment. That's significant. Time served credit means the days a defendant spends in jail before sentencing can count toward the final sentence imposed by the court. In this situation, the defense is essentially saying the punishment has already happened. Given that the defendant is also facing a separate MDOC sentence expected to carry a minimum of 36 months, the defense argues that additional incarceration for this misdemeanor would serve little practical purpose. This is where judicial discretion becomes extremely important. Judges must balance accountability with proportional punishment. Too harsh a sentence could be seen as excessive given the time already served, too lenient, and the public might question whether justice was properly enforced. Moments like this demonstrate how sentencing decisions involve far more nuance than simply applying a number from a statute.
So given the time that she served and the time that she will serve, we're asking for credit for time served on this case.
Ms. Miller, is there anything you want to tell the court before I impose sentence?
Thank you for your time and consideration on this. I would just really like to close this matter and so I can move forward. I appreciate it. Thank you.
Sentence of the court, state minimums of $125. And then I'll order 365 days incarceration credit for 365 served. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Have a nice day, sir. Thank you, ma'am.
Thank you, Ms. Miller.
Court calls case of the people versus Jonah Witt. I'm sorry. Uh-oh. Well, that they did something. Hold on, folks. I don't know where I picked that up from. I just saw it. Never mind. Court does call the case of the people versus Rudy Becerra.
Maria Rosinski on behalf of the people.
Mr. Banas. Mr. Banas.
Not Mr. Badness, but Attorney Feaster, Assistant Public Defender on behalf of the defendant. Oh, there he is. Please state your name for the record, sir.
Rudy Becerra.
Thank you, sir.
Your Honor, I'm so sorry. I was talking to one of our investigators, Andrew Banas, on behalf of Mr.
Well, thank you for joining us. Go ahead. What are we doing on this?
It's my pleasure, sir. But seriously, I do apologize. I did speak with Mr. Becerra. He is waiving exam for resolution up in circuit court. And if helpful to know, he reports to me that he expects to be released from custody, hopefully any day now, on parole. And I do not believe this case would constitute any kind of parole violation.
Sir, you've heard what your attorney has indicated?
Yes.
All right. You understand that if you waive your preliminary examination, that is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
When a defendant waives a preliminary examination, it means they are giving up the opportunity to challenge the prosecution's evidence at this stage. Instead, the case moves directly to circuit court. At first glance, that might seem risky. Why skip a chance to test the prosecution's case? But in reality, waiving the preliminary exam can be a strategic move. Sometimes the defense knows the evidence is strong, and the hearing would only reveal more information that strengthens the prosecution's case. Other times, the defense may already be negotiating toward a resolution in a higher court. So waiving the exam doesn't necessarily mean surrendering. It can simply be part of a broader legal strategy. Here's a question for you watching. If you were facing serious charges and your attorney advised skipping a hearing that could challenge the evidence, would you trust that strategy? Or would you want to fight every step of the way?
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over on count one with two following. Mr. Banas.
Your Honor, I acknowledge receipt of the information, and Mr. Becerra stands mute and waives formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea to both counts. Pretrial in this matter will be set for
September 26th at 1:30 p.m. with Judge Conkey.
September 26, 2023, 1:30 for Judge Conkey. Bond will continue in this case. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of the people versus Darnell Taylor.
Ready, Judge.
Maria Rosinski on behalf of the people.
Portia Feaster, Assistant Public Defender on behalf of Darnell Taylor. Mr. Taylor, please state your name for the record.
Darnell Allen Taylor.
Thank you, Judge. We're just asking for the soonest possible preliminary examination date, please.
Would everybody be ready to go on the 12th? I can do the 12th or 19th. Which day?
Ms. Kirby's shaking her head, not the 12th, it appears, Judge. So the 19th, I assume.
You saw her shake her head? I wasn't paying attention. All right. Preliminary examination in person, September 19th, 2023, 9 a.m. And that will be before Judge Valvo.
Thank you, Judge.
All right,
Thank you, Bond. Bond will continue. Thank you. Court calls the case, People versus Hassan Al-Sabar.
Caitlin Kirby on behalf of the people.
Good morning, Your Honor. Barry Resnick appearing on behalf of Mr. Alsabar.
Good morning. Al-Sabar, can you state your name, please?
Good morning, Your Honor. My name is Hassan El-Sabar.
iPhone 1. All right. All right, what are we doing?
Judge, I just, in the process of getting some discovery, I need to review with Mr. Sabar. If we could have an adjournment of PCC, waive the 14-day rule, I can assure the court that there's an extremely good likelihood on the next date that we'll be able to waive it over a circuit.
Probable cause conference, September 28th. He's out.
Your Honor, is it possible we could do it the following week, as I have another hearing on that date? The 5th, if we could do that, I'd appreciate it.
What's the date? Any objection from the people?
No, Your Honor.
October 5th, 2023, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor. Nice seeing you again.
Good seeing you, sir.
Thank
Court does call the cases of the People versus Nicole St. Germain.
Ready again, Judge.
Good morning, Your Honor. Nicole Hughes on behalf of the people.
Portia Feaster, again, Assistant Public Defender on behalf of Ms. Nicole St. Germain. Please state your name for the record, ma'am.
Nicole St. Germain.
Thank you, Judge. At this time, there wasn't an offer on this file. Based on that, Mr. St. Germain is asking that we have these matters set for preliminary examination, please.
Preliminary examination in person will be set September 19th, 2023, 9 a.m. And that is before Judge Fresh Hour.
What? This is way too
I'll let her know you said who. That would be Judge Anna Fresh Hour, man.
I was supposed to be let out today.
No, ma'am. No, ma'am. We're setting it for exam, and then we'll try to resolve it at that point and try and get.
What does that mean?
That's what we discussed, where we're going to set it so the witnesses have to come to court to testify, or we can resolve it with a plea.
I thought if they didn't come today, that you could resolve it with a plea.
No, ma'am. That's at exam.
So wait, what's happening?
Okay, I'll come see you again, and we'll talk about it again.
Oh no, I'm just wondering because you told me that if they didn't show up for court today, that it would be dismissed.
No, ma'am. I said a preliminary examination. Cases are often dismissed if the witnesses do not appear. But we can talk about it. I'll come see you.
Appear.
All right, Nicole, come on.
All right, you guys done?
I'm sorry, Judge.
Okay, no, it's okay.
You're
'Cause I
supposed to
was
be
done a while
released today.
ago.
That's what we were
But
talking
I was
about.
gonna let you go.
Okay, I appreciate it, Judge. Ms. St. Germain, I'll come see you again. Your next court date is 9/19.
All right,
Okay, well, what? I just, that's not really what we talked about.
come on, Nicole.
All right, thank you.
Why did they laugh during mine?
Court calls the case of the People versus James Williamson.
What we've just witnessed is a snapshot of how real courtroom proceedings unfold, not as dramatic courtroom showdowns every minute, but as a complex sequence of legal decisions, negotiations, and procedural safeguards. Across this session, Judge Simpson handled multiple cases involving adjournments, plea negotiations, sentencing decisions, and preliminary examination scheduling. Each moment demonstrates how the justice system balances efficiency with fairness. We saw defendants negotiating pleas, attorneys coordinating strategy, and the court carefully ensuring that every defendant understood their rights before making legally binding decisions. Perhaps the most important takeaway is this: the courtroom isn't just about determining guilt or innocence, and it's about managing a process designed to protect legal rights while resolving cases as fairly and efficiently as possible. And every decision, from adjournments to guilty pleas, can have long-term consequences that extend far beyond the courtroom walls. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.